5 seconds to go. The Chhattisgarh High Court recently ruled that the reservation policy for SC/ST in promotions must be established based on quantifiable data and in accordance with Article 16 4A and 4B of the Constitution. The division bench comprising Chief Justice and Justice held reservation policy for SC and ST in promotion can be framed only on the basis of yardstick fixed for collecting quantifiable data by the Honorable Supreme Court in various authoritative pronouncements and also based on the provisions contained in Article 16 4A and 4B of the Constitution of India. The occasion to hold this arose while the court was dealing with a batch of petitions challenging three notifications of the state government dated 31/10/2019, 22/10/2019, and 30/10/2019, alleging them to be violative of Articles 14 and 16 4A of the Indian Constitution. The state government amended the reservation percentages to 13% for scheduled castes and 32% for scheduled tribes from the previous 15% and 23% respectively. It was specifically pleaded by the petitioners that the three notifications were contrary to the provisions of Articles 14 and 16 4A of the Constitution and in violation of orders issued by the Supreme Court and this court. The petitioner's primary contention was that the amendment-wide notification of October 22, 2019 was implemented without adhering to the directives issued by the coordinate bench and without obtaining quantifiable data as mandated by law. Advocate counsel for the petitioners contended that the state's issuance of the notification dated 22/10/2019 without first collecting quantifiable data violates Articles 14 and 16 4A and 4B of the Indian Constitution as well as orders from this court and the Supreme Court. It was emphasized that although a committee was established on July 17, 2020 to gather quantifiable data, this occurred subsequent to the issuance of the amendment contradicting established legal principles set by the Supreme Court. It was further argued that the committee's formation on 17/7/2020 and subsequent submission of its report on 17/10/2021 indicate an arbitrary exercise of authority. Additionally, it was stated that the state must collect data based on specific job categories, yet the committee made decisions without obtaining this data, relying solely on the number of vacant positions reserved for SC and ST categories in direct appointments and promotions. On the other hand, senior advocate representing the respondents argued that the state possessed quantifiable data before enacting the promotions rules of 2003. He emphasized that the state's decision wasn't made without such data. He pointed out that long before the Supreme Court's judgments in the cases of M. Nagaraj and Jarnail Singh, there existed the Chhattisgarh Public Service Reservation for Scheduled Caste, Scheduled Tribe and Other Backward Classes Act of 1994. This legislation detailed vacancy positions and employment statistics within the state and mandated the preparation and submission of an annual report to the Vidhan Sabha under Section 19. Senior counsel Hegde also argued that the state thoroughly understood the specific requirements of various social groups. This knowledge was acknowledged and formally documented in reports submitted to the court. The attention of the court was further drawn to the fact that none of the office bearers of the society had come forward to even affirm the affidavit in support of the petition, and that the writ petition itself had been preferred on the strength of an affidavit of a 24-year appellant who was stated to be engaged in farming